The Supreme Court of the State of Colorado is now in session. Chief Justice Goldberg presiding.
You may be seated. Thank you. All right. First case on the docket this morning is 22SC499, University of Denver versus Respondent John Doe. Counsel, if I could have you come up to the podium when you enter your appearances so people online will know who's talking, I would appreciate it.
Good morning. Josh Richards for the University of Denver, petitioner in this matter.
All right, welcome.
Good morning, Your Honor. Michael Marabella for Respondent John Doe. I'm joined at table by Caleb Ray.
All right, welcome. All right, are you going to be doing the entirety of the argument, both counsel?
Yes, Your Honor.
Yes, okay. All right, we are set for an hour. Both sides will have 30 minutes. And is it Richards?
Yes, Your Honor.
All right, Mr. Richards, you can use any time you have left over for rebuttal, but you'll need to keep track of your own time, and you can begin when you're ready.
I'd like to reserve 12 minutes for rebuttal, and I will keep track of my own time, Your Honor. Thank you. May it please the court, this case is important because the Colorado Court of Appeals has abrogated a significant body of this court's longstanding legal rules. Reversal is warranted here because in addition to failing to follow this court's precedents, the Court of Appeals has set an unwise, unworkable, and confusing standard that will inhibit Colorado's ability to contract reliably by understanding the terms that they're agreeing to. And it also wipes away important limitations on the creation of new tort duties. I think this court should reverse and hold that the words thorough, impartial, and fair are not capable of meaningful determination and therefore have no contractual meaning.
All right, let me jump in right away here, Mr. Richards. Good morning to you. So you started your brief, or earlier in your brief, you said the Court of Appeals allowed a claim for failure to provide thorough, impartial, and a fair hearing, and you kind of allude to that today. Didn't the Court of Appeals directly reject that? They said specifically thorough, impartial, and fair is not enough, that you also need specific procedures laid out.
Yeah, so the Court of Appeals did say that specifically, but the rest of its opinion, I don't think sort of stuck with that or followed through.
Well, why not? And I'm going to push you a little bit. You may know I came from the Court of Appeals, and it's troubling to me when I read opinions or read briefs that I think misrepresent what the Court of Appeals did, and I say that respectfully. I think they did. I mean, they talked about you got to talk to witnesses, you got to give people a chance to be heard and the like. I mean, what happened here was, Jane Doe list 11 witnesses, they talked to all of them. John Doe list, 9? They didn't talk to any of them first, and then they talked to one of them. These were the things the Court of Appeals relied on. So how is it you say they didn't stick to it? That was the grounds that they relied on.
Well, Your Honor, that isn't the issue that was raised by Mr. Doe. The appeal raised the question of whether the investigation was thorough, impartial, and fair. And the Court of Appeals, rather than saying that those terms had meaning, said, well, we can only find out what those terms mean by applying them elsewhere in the agreement. But respectfully, I think the Court of Appeals got it backwards, right? When we have a handbook of this sort that describes what an institution intends to do under a given set of circumstances, it starts out with prefatory language. We're going to have a thorough, impartial, and fair process. We're going to conduct that process with sensitivity and respectfully, two terms that the Court of Appeals didn't say could have contractual meaning, but I would submit are equally capable of meaningful determination on this record. And then we describe what it is that process is going to be. And in fact, if you look at the Court of Appeals' support for the position it took, it cites the Doe v. University of Pennsylvania case. In that case, the court confronted an identical set of circumstances. Fair procedures, what are they? And the court explained, and I think we argue here, that thorough, impartial, and fair describes what is to come. Here is the process that we're going to conduct.
So I'm going to stop you there, counsel. Sorry. Good morning.
Morning.
What we're here to talk about today is whether there was a contract between the university and Mr. Doe. And I think, Do you agree with me that that's the issue here?
The issue here is whether thorough, impartial, and fair are
Nope.
capable
So
of.
that's the issue you want to focus on. But I think I'm following up on Justice Gabriel's question, the way that this has gone, that this went in the Court of Appeals was not actually focused on thorough, impartial, and fair exclusively. It was focused on thorough, impartial, and fair as informed by the details of the process that the university said it would follow. And the question is, did the university follow the procedures it said it would follow in a way that was thorough, impartial, and fair?
Well, Your Honor, in order to sort of answer the question in that way, we have to first ask whether we can meaningfully determine whether something is fair, right? So,
Okay, so let me stop you again. How about, what if we don't know about fair? Fair is a hard one, I agree. Did the university follow the procedures it said it would follow in a way that was thorough? Can we figure that out?
I'm sorry, and let me add to Justice Hart's question. What the Court of Appeals said was that the investigation required that the investigator conduct interviews as necessary, review documents and any other relevant information. The parties will have, quote, an equal opportunity to be heard, I think it's presenting information, to identify witnesses who have relevant information. The investigators must review and determine the weight and materiality of all submitted information. Those are specific things in here, not just fair and I actually would agree with you. If it just said fair, impartial, and thorough, you would have a much stronger argument. But it has all of those things, and that's what the Court of Appeals focused on. So returning to what Justice Hart was also asking you, isn't that the question before us? When you have policies that lay out those things, can they be an enforceable contract? Isn't that the question?
So I apologize, I misapprehended the question. The answer is when a university makes specific commitments to follow through on specific actions, some courts, although not this one, have ruled that that constitutes a contract, and that a student can say, you told me that you would consider the information that I provided. You told me that you would interview witnesses. You told me that you would provide me notice of the claims against me. Did you do these things? That's enforceable in contract. In this case, the district court examined all those issues and entered summary judgment as to each of them, and that was not appealed. The issue of whether or not those specific enumerated obligations were fulfilled isn't before this court. That's an issue that was decided at summary judgment, was not appealed to the Court of Appeals. The only question from the Court of Appeals was the way that the university conducted its process
Well,
thorough,
and
impartial,
again,
and fair?
I'm sorry I'm beating on you here, Mr. Richards, and I do it respectfully, and I know you're taking it that way. Didn't the Court of Appeals conclude that there were fact questions that precluded summary judgment? The ultimate holding of the case was reversed because, number one, there's a binding there is at least an enforceable contract, and number two, we have fact questions that preclude the granting of summary judgment. That was the holding of the division.
Respectfully, Your Honor, if the division held that individual promises contained in the handbook were breached, then it did so beyond the scope of what was before it. And in that, I would submit, acted inappropriately. The question appealed and presented to the court was whether the investigation was conducted in a thorough, impartial, and fair manner.
So
That's-
we're right now honing right in on what drove me a little mad while I was reading the briefs and the opinion. You say that, and I don't disagree with you, and maybe the question wasn't as artfully framed as it should have been on appeal, but we have a Court of Appeals opinion that very plainly talked about more than just the words thorough, impartial, and fair, that talked about the specific procedures. So when you say to us, you're only supposed to look at thorough, impartial, and fair, it's why people don't like lawyers, it feels like, but wait, what we have in front of us is an opinion that talks about all these other things. So why are we only allowed to talk about thorough, impartial, and fair?
So I take your point, Justice Hart, and I have sort of two answers if I could get some indulgence. The first is that, of course, we don't frame the question for the Court of Appeals coming out of the district court. And so, we respond to the appeal that's filed. The second, I think, better answer, the non-lawyerly answer, is that at some point we do need to dig into this issue of whether or not the terms thorough, impartial, or fair as modifying specific terms in the contract, which, let's assume for this purpose, because the Court of Appeals said that it was a contract, that when we say we're going to thoroughly interview witnesses or we're going to fairly provide notice. I mean, that's really what this is about, because we know that the district court said that on their face, the actual specific promises were satisfied. So the only way that this presents a question for this court is if we can say, well, we didn't fairly interview witnesses. So we need to talk about what that means. How can we determine whether witnesses were interviewed fairly? If John Doe had presented 200 witnesses and Jane Roe had only presented one, is fair interviewing all 200? Is it interviewing one for each? The answer is we can't know. And because we can't know, because there isn't an easy answer, it can't be an enforceable contractual term, because it's not. The answers to all those questions have to be easy if the parties had a meeting of the minds with respect to what the obligation was.
Mr. Richards, good morning. So what if the policy said specifically a thorough, impartial, and fair investigation is one that complies with, and then listed all the procedures that are contained? If that were the case, different outcome?
Same outcome, clearer in terms of the intent, I suppose. But this court and lower courts have long talked about what we do when we have sort of vague assurances of fairness. So in the Hoyt v. Target case, the Court of Appeals talked about how sort of an assurance of fairness in a disciplinary proceeding doesn't mean anything on its own.
Right, and I get that, but if you say fair, impartial, thorough means 1, 2, 3, 4, 5, these procedures, you have to give notice. You have to interview every witness who's relevant. You have to investigate any motive that the claimant may have. You have to consider a sane report in its entirety, not self-selected portions. What's wrong with that? Why is that not definitive enough?
So I think that the policy at issue here does that. I think that if the court reviews the way the policy is set up, then the language around the terms thorough, impartial, and fair includes words like respectfully, with sensitivity, the sort of things that talk about the quality of the investigation as a whole.
But what about the things that I identified for you? I mean, I read you from the Court of Appeals opinion, the things that they were saying was enough. I mean, the holding is paragraph 45. Our holding is limited to concluding that the contractual term providing for a thorough, impartial, and fair investigation, coupled with prescribed investigation requirements, is sufficiently definite and certain to be enforced under Colorado contract law. And the next sentence is the heading. Genuine issues of material fact precluded summary judgment. You keep focusing on, they just said fair, they just said fair. They said, I'll ask you to accept as a given, they said more than that. It says what it says. But I'm troubled, and you seem to say what wasn't in front of them. This is your cert petition. And if you want to go that way, and I'm just playing devil's advocate now with you, is cert improvidently granted? Because you technically didn't challenge the holding that there were fact questions here.
Well, respectfully, Your Honor, we did, and I don't agree with the Court of Appeals that there are fact questions for two different reasons. First, because just in the way that I answered Justice's Hart question, How would the Court of Appeals intend that we resolve a fact question about whether the witnesses were fairly interviewed?
Well, simple. I mean, a jury question as to whether, all right, Jane puts up 11 witnesses, they talk to all of them. John puts up 9 witnesses. Initially, they talk to none, and then they talk to one. The Court of Appeals here and the 10th Circuit said that the investigators never looked at Jane's motives, and there were motives here. You say to the jury, is that properly considering all the witnesses? Did the parties fairly have the opportunity to be heard? Why is that not a reasonable fact question?
And if I could just, I'm going to, from I think your side, add to that. I mean, I think there could be very plausible explanations for why you didn't interview all of John's witnesses. Some of them were in the briefing. But that is, I think, as Justice Gabriel said, it's a fact question that the jury should be able to decide. We're at summary judgment here. So why doesn't this go to the jury?
There's no fact question because there's no dispute about how many witnesses got interviewed. The only
Well, there is, I'm sorry, there is a fact question. Is interviewing only, I think it was actually 2 of John's witnesses, whereas you interviewed 11 of Jane's witnesses. Is that thorough, fair, and impartial?
And again, that brings us back to whether thorough, fair, and impartial are capable of meaningful determination. So we have a jury full of people, and one juror puts his hand up and says, does fair mean the same number of witnesses? And a different juror puts his hand up and says, does fair mean you interview everyone that everybody asks for? And another juror puts up his hand and says, well, does fair mean if you don't interview 2 of one person's witnesses, do not interview 2 of the others? And the reason that conversation is happening, I'm sorry, Yari.
No. I interrupted you, so you shouldn't apologize. But I guess, are you in essence arguing that there is no way to have a contract around this kind of a policy, a Title IX policy at a university? That it's fundamentally a question of Title IX law, and it can never be, because I think that's your argument on the tort side. Are you also saying it just can't ever be a contract question?
I think our position on that, Your Honor, is slightly more nuanced, which is that the question of whether a Title IX policy or any other school policy constitutes a contract relies on principles of contracting under Colorado law. Some policies might say, this policy does not constitute a contract. Or some policies might say, this policy is unilaterally changeable by one party but not the other. In that situation, I don't think that contract law would apply. But in other situations, it might. I'm not inviting this court to make a categorical ruling on that point. But I do think that it would not be correct to say that there's a fact question with respect to a term which this court and others have held isn't capable of contractual meaning. So I think when we say, is there a fact question as to whether or not this was fair, that really does put the nub on the question. Because how on earth can we expect a jury to understand what John Doe and the university mutually understood the word fair to mean, to then to decide whether or not that mutual understanding, which may have created a contract, had been violated? You can't put that on a term like fair, and therefore you can't impose it on other terms in the policy through the word fair. Fair notice, fair interviewing of witnesses. It doesn't work, which is why it can't create a fact question, because it can't create the predicate agreement.
Mr. Richards, you had indicated that you were hoping to save, I think, 12 minutes for
Yes,
rebuttal.
Your Honor.
That seems increasingly unlikely, but can you just pivot to the tort issue and talk to us specifically about why there's no duty in tort?
Yes, and thank you, Your Honor. There are a number of what I view as insurmountable problems to creating a tort here. And to do so, I think the court would have to abrogate a number of prior rules that it has. The first rule that's incredibly important here is the idea of whether duty can be created absent a special relationship. And there's no question that there's no special relationship here. The parties agree on that. And there's also no question that this is a non-feasance as opposed to a misfeasance case. The parties also agree on that. And we have, and respectfully to the Court of Appeals ruling, the Court of Appeals focused on the Health One case. The Health One case arose in the medical context. It cited but didn't examine the Whitlock case, which arose not just in the higher education context, but with specifically this party, in which this court held that no duty was owed by a college or university to its adult students. Now, since Whitlock and Health One were decided, this court has twice affirmed the notion that in a nonfeasance case, we don't find a duty absent a special relationship. And to me, that's just sort of open and shut here. I mean, to add on top of that, this also isn't a paradigmatic duty case to begin with, right? I mean, ordinarily, torts arise in situations where there's a risk of bodily harm as opposed to economic harm. This is a pure economic harm case, and to the extent that there's any argument that there were sort of emotional damages here which would reflect bodily harm, this court has also held that a tort doesn't arise under those circumstances unless there's unreasonable risk of actual physical injury.
So, Mr. Richards, your position is we don't even have to get to the Weston factors.
No, Your Honor. And so we don't get to the Weston factors for that reason. We also don't get to the Weston factors because of the independent duty rule, right? We have not just potentially one in the form of a contractual obligation, which of course the Court of Appeals determined that there was, but then declined to examine whether or not that precluded a duty in tort. And, you know, this court has held in Raup, in Town of Alma, in a number of cases. I'm sorry, Raup wasn't this court's case. It was a federal case. But in Town of Alma and in other cases, the Court of Appeals held in Chelson that in situations where there's already an existing duty, and here there are at least 3 that I can count. There's a potential contract, again, going with the courts. There's Title IX, and there's also a Colorado statute. So the legislature in Colorado has already spoken with respect to the creation of a duty here and has created a duty to have certain procedures that arise.
Mr. Richards, if I can ask you, and I'll put some more cards on the table and tell you this argument resonates far more than your first one with me, and I think you've got a stronger argument, particularly the last point you made. But why is this a nonfeasance case? I get that there are other duties, and I'm going to tell you that argument has a lot of resonance with me. But why is it nonfeasance as opposed to, from the plaintiff's side, they just performed an inappropriate investigation? They didn't, but I'll leave it at that.
So I will be the first to admit, Your Honor, that the nonfeasance, misfeasance distinction is sometimes a little bit tricky to apply. But I would say that in this context, you know, the Wagner case comes to mind where, you know, and again, footnote that all of these cases that we're talking about are bodily injury cases, right? So we're already far closer to a tort than in this case. But in the Wagner case, the allegation was you didn't follow the security procedures that you had said that you would follow. That's a misfeasance case according to this court. In the Trujillo case, again, a danger existed and the party didn't do enough to stop the danger from occurring. That's also a misfeasance case according to this court. And of course, we have the Whitlock case, which we would submit as on all fours, also a nonfeasance case. And so you know, I think it's...
Sorry, for the first 2 that you just talked about, you said they were misfeasance cases.
Sorry, they're nonfeasance cases. I misspoke. I apologize.
Okay, so you meant to say for those 2 cases, they were non-feasance
That's right.
cases.
And those cases are very much like this case, I would submit, in terms of the way that the case has been pleaded. You had these procedures that you were supposed to be following, you didn't follow them, and this thing happened.
Okay.
And so, you know, I would submit that the combination of that case law and the fact that this is not a bodily injury case strongly militates in favor of a finding of no tort. Of course, we discussed in our papers that this is also an educational malpractice claim, right? Essentially what we're hearing here is I paid for services. The services that were provided to me in the educational context were not what I had asked for. And that theory has been, I think, conclusively struck down by this court in the Sencor case. So I think in order to find that there was a duty here, before we even get to looking at the Weston factors, we have to abrogate the independent duty rule, we have to abrogate the Whitlock holding with respect to nonfeasance, misfeasance, and we have to abrogate the educational malpractice rule. I just think that that's insurmountable. I see I'm down to, 6.5 minutes. If it's all right, I'd like to reserve the rest of that for rebuttal.
Not seeing any questions, you may. Thank you, Mr.
Thank you,
Richards. Mr. Marabella, when you're ready.
Thank you, Your Honors. Given that we were talking about negligence, I'd like to start with negligence, but we do have two broad issues to talk about. Whether or not there's negligence either in the presence of a contract or without a contract, and whether or not the contract is enforceable, the terms of the contract are enforceable.
I'm going to jump in at the very beginning. Can you please turn your attention to the nonfeasance, misfeasance argument?
Certainly. I was going to start there. Thank you. I believe in this case, given the facts, that it is a malfeasance case. They have an active investigation, and they are actively choosing what they're going to do and what they're not going to do. We're not going to interview witnesses. We're not going to consider motivation. We're not going to look at all the documents. So this is a malfeasance case, not a misfeasance case. Given the other important thing to consider is you might.
And can you point us to any cases that sort of support kind of that line of thinking?
I really can't, Your Honor. I didn't put any in my brief, and I haven't pursued that because, frankly, it seems so obvious to me that I didn't pursue that.
Thank you.
The court may be wondering why we're discussing negligence at all, given the contractual issues. And there's two reasons that the court needs to consider. The first is the availability of non-economic damages, which if it's a contract case is not available. And if it's a Title IX case under the Cummings case from the U.S. Supreme Court recently, is also no longer available. The Court of Appeals noted that in cases such as this, there are both large economic damages and large non-economic damages. And if the court is going to allow for a student who has been injured non-economically to have any hope of relief for that damage, they're going to have to recognize.
Whoops, I don't think, so you're basically saying we have to recognize a tort because that way there'll be big damages?
No,
I guess.
what I'm saying is there are damages there, and the only place that those damages can be relieved is with negligence. You still have to go through the Weston factors. You still have to review all of the other issues. But in the current state of the law, there's no other way for those non-economic damages to be rewarded.
So that feels to me like, I don't know if it's really the tail wagging the dog, because it's maybe the dog wagging the tail, but like the reason to recognize a tort is damages.
No, Your
Whereas there are lots of reasons not to recognize a tort here, I think. There is a Title IX claim. There may or may not be a contract claim under the specific terms here.
Certainly.
But so
I'm just pointing out why we're even arguing about negligence.
Okay.
I'm not saying that that is a reason to find that there is a duty.
okay, so let's then talk about other reasons not related to the damages.
Okay.
To recognize a tort in the context where it's already covered by federal law and potentially a contract suit.
The second reason I think the court should be aware of is that since the Court of Appeals decision, schools have been placing contractual disclaimers into their OEO proceedings to abrogate the contract claim.
So that would take away a contract claim. You can't take away the federal statutory Title IX claim though, right? I mean, that's
still
there.
Yes.
So can you address those cases? Mr. Richards alluded to it, and they cite a number of cases that say when you have duties created by contracts or statutory law, we're not going to recognize a tort claim. Are there cases going the other way?
You know, the Alma case really says Not that they're not going to recognize a negligence claim, simply that the negligence duties are going to be defined by the contract.
But then you run into an economic loss rule problem.
Right.
And so that also counsels against recognizing a tort claim here, doesn't it?
Except for the additional damages that are available under the negligence claim, yes. So the Court of Appeals carefully reviewed the factors set out in Weston. The risk of harm from an improper investigation, the foreseeability of that harm to the student versus the social utility of the university's conduct, the burden on the university to avoid that injury, and it also applied the Taco Bell case, which I think is extremely interesting because the Taco Bell case said that it's a standard of fairness under contemporary standards, and would reasonable people find that this duty exists as a matter of fairness? This court, and almost every court, applies fairness all the time. It's not a vague standard.
So, Mr. Mirabella, good morning.
Good morning.
You're right. The division, and it was Judge Berger who authored the majority opinion, a very smart jurist, and he applied the Weston factors. But so did Judge Hoffman, another smart jurist, and he came to the exact opposite conclusion. So when I look at the Weston factors, I think you can go out either way, and you can justify it either way. So help me with that. How helpful are these factors?
Well, I didn't write the factors. I just found that Judge Berger applied them more correctly. Judge Hoffman did not find that fairness was something that you could consider. I don't think Judge Hoffman applied Taco Bell, if I recall correctly, and Judge Berger did apply Taco Bell. So what would people expect when you do a investigation, when you're going to be investigated, and you say, here's the information, investigator? You expect the investigator to look at that information. You may not like the result. And I've done hundreds, thousands of cases in my career, and I don't always like the result that a judge comes up with or a jury comes up with, but I expect them to review it fairly. Same thing here. Mr. Doe expected that the OEO office was going to review his information fairly. It wasn't going to just dismiss it. It wasn't going to just say, oh, they're all his friends. They're going to say what he wants them to say. They didn't apply that
They didn't say that,
consideration.
though, right? They didn't, excuse me. I think they actually said, as to Jane Rose witnesses, that they discounted their testimony because they were her friends and were going to say it her way. With respect to John Doe's proposed witnesses, they said, we don't need to talk to them because they're just going to say things we already agree to. They would just support things we've already concluded are the case. So when we talk about fairness, I guess looking at the explanation that the university gave for why it did things the way it did, again, this seems like a fact question to me, but couldn't a reasonable person think, that makes sense, if they were just going to corroborate what they already had decided, we don't need more?
The middle of your question makes the point. It's for the jury to decide that.
Yep.
I don't think it makes sense to discount a witness because you think you know what they're going to say, or you think it's already been explained. In my experience, witnesses say things that you don't expect, explanations that you think they're going to corroborate, they don't. So it's important to do the thorough, fair, impartial investigation.
Mr. Mirabella, can you respond directly to opposing counsel's argument that that sort of regime just ends up allowing for too many subjective ad hoc determinations of what's thorough, impartial, and fair? So it's so, I mean, it's to the overarching point, right? It's just so nebulous that you don't really provide appropriate lines for people to make decisions by.
Well, in discussing this with counsel who's assisted me and and friends and family. It's interesting to me how many times people quote Justice Brennan talking about pornography, that he didn't know what pornography was, but he knew it when he saw it. Same thing with fairness. You may not be able to define it, but you know when you see something unfair happening. And again, it's for the jury to determine what's fair, what's unfair.
Do you want to weigh in on the debate that we were having earlier about the extent to which the Court of Appeals opinion really rests on the delineation of specific procedures as opposed to just this thorough, impartial, and fair standard?
Well, I agree that the Court of Appeals, in following the University of Pennsylvania case, followed the right procedure. You don't look at a phrase or a single word and say that is the overarching reason of the contract. You have to look at the entire thing in context and in context of what the parties intended. The parties intended to have a fair procedure that would make sure that the goals of Title IX were met, no matter what the gender of the student involved in that is. And the example again, talking to people and preparing, we can easily imagine in the 1960s or early 70s when I was going to school, a hockey star gets accused of sexual assault. And who investigates it? The athletic director and the hockey coach. And that's clearly unfair. What happened here? A student was accused of sexual assault, and who investigates it? A woman who immediately said that the accuser was a victim and covered up information about the victim's motive.
Well, let me ask, if I can, Mr. Mirabella, to come at Justice Hood's question in a slightly different way. Would you agree that if the contract or the policy here said nothing more than thorough, impartial, and fair, and didn't lay out procedures, would you agree that that is not a legally binding contract?
I think it would be very difficult to make that a legally binding
All right, so you would agree that you need specifically delineated procedures that weren't followed?
I do agree. And that's
So
why the Court of Appeals reached the correct decision.
So if that's the case, why aren't we just talking about the specific procedures that were allegedly breached here? I mean, as the more I read the briefs and the Court of Appeals opinion, the more I wondered, then why bring the claim about fair, thorough, impartial, if what saves it, according to your position and according to the Court of Appeals, are the specific procedures, then why not just say these are the specific procedures that were violated here?
I think we argued that, but I don't think we, as Justice Hart mentioned, I don't think we argued it probably as well as we should have, framed it as well as we should have. And certainly in listening to the arguments this morning, I wish I could get a time machine and go back and redraft it, but we're stuck with what we got.
I appreciate your candor.
Mr. Mirabella, then let me ask, what is the contract here? Tell me what the contract is.
Well, I think if you look at the Sencor case, Sencor says that the relationship between the student and the school is a contractual relationship, and it says the materials provided by the school may be a part of that contract. In this case, we're arguing that it is a
Can I
part of the
follow up?
contract.
So what in the material specifically gives rise to the contract here?
The OEO procedures that they were supposed to follow that they did not follow.
That, I think, kind of raises the question that the court framed and added to the case, which is whether federally required policies can in fact ever be a contract. If you're mandated by law, was there ever a meeting of the minds with regard to the OEO policy?
Yeah, we struggled with why the court put that in as an issue, because it's not the facts in this case. We have a contract.
Can you elaborate on that?
Yeah, we have a contract, and the contract specifically adopts the Title IX.
And so is the contract, sorry, you have a contract, is the contract broader than the OEO policy?
Well, the OEO policy portion of the contract is what's at issue here in this
But
case.
it's part
their
of a larger
Yeah,
contract,
their
which
contract
is-
is larger than that.
Which is all of the school's policies, or?
It starts with, we're going to provide you classes, and if you meet all our requirements, we're going to give you a degree.
Okay,
And it
so it's
goes to,
everything that the school tells the student.
it can be, yes.
Okay.
It depends on the particular issue.
Some,
but
some
yes.
parts of which, including potentially the OEO policy, may be mandated by law.
Right. But we do that all the time in other types of contracts. In
Well, say-
construction contracts, a lot of my work during my career has been construction-related contracts. OSHA and workers' compensation are either directly or impliedly part of the contract. In defense provisions, Defense Department contracts, the enabling legislation that lays out specifications are part of the contract.
That
In
makes
public works contracts, the specifications that were approved are part of the contract. Whether they're specifically called out or not, they're included.
That makes sense. Thank you.
So, Mr. Mirabella, you see no difference between this context and, say, the context that our court dealt with in Sancor?
Oh, no, those are very different cases, but the holding of the case is that the student-school relationship is contractual. I don't think that's an assailable point at all. And then that the materials that are provided by the school, depending on what those materials are and what topics they reach, may be part of that contract.
Okay,
And-
and
and
that's what I meant. I just didn't ask it artfully, but just as the materials there can be part of a contract, your position is so too can the materials here.
Yes.
Even though those are dealing with a different subject than the ones that we have in front of us here, obviously.
Yes.
Okay.
And what are the limits on that, right? So there's what you're arguing here, is every kind of material that a university gives a student, taking your argument to the logical sort of conclusion, the basis for a contract?
I would think, maybe the menu in the cafeteria is not something that goes more to the educational or, in this case, disciplinary foundations is.
Is
I
there-
can think of things that aren't and things that are, but I
Any-
can't
anything
draw
for
a bright
us?
line for you. I haven't thought about that. That's a good question.
Nothing else for us besides the menu?
Well, Cencor goes on to say, the quality of your instruction is not part of the contract. And if you say, we're going to give you a great education, that's not part of the contract. That kind of goes to a argument about fair, impartial, and thorough without having all of the detail provided by the OEO proceedings.
Is there a student handbook or, I mean, I'm trying to analogize, I guess, to employment law where an employee handbook can be a contract between the employer and the employee.
I think under Colorado law, employment and education are really different.
I agree. I'm just trying to analogize. I'm not, but is there, I mean, you're saying, it seems to me sort of in response to Justice Birkencutter's question, is everything on the website, other than a menu, a contract with the students, or is there somewhere that we can memorialize these things are contractual?
It's been so many decades since I've been in school. I'm not sure what's in all of those. I don't know what's in all of Mr. Doe's materials that were provided to him. Our concern here is the materials that were provided to him about the OEO procedures and whether or not those are contracts. I really can't help the court draw a bright line about other things that are not part of this record. I'm sorry about that.
And the OEO policy was provided to him as part of a handbook or a?
Yes, it's provided to all the students, along with other handbooks and guides that might or might not be, depending on what the claim might be. Given my time limitations, I guess I'd like to go to the contractual issue. And I think, the court already discussed it with counsel at some length, but you don't, as we discussed, you don't just focus on a single phrase or a single word. You have to interpret the entire contract as a whole, given what everyone understood to be the goals of the contract. The goals of the contract with regard to the OEO procedures is that you're going to have a fair opportunity to make your position known and to have all of the evidence reviewed. Using the overall context of all those procedures, thorough, impartial, and fair, as illustrated and enlightened by those procedures, is a term that can be enforced and is understood by most people.
So let me pick up, if I can, on Justice Moore's question and ask if you would identify for us very specifically what procedures you would allege were violated here. Be specific.
I'm not sure if I can do all of them off the top of my head, but certainly
Give us a number of them that were
there were a
violated.
number of them, and I guess I would point you to the 10th Circuit's opinion, because they were looking at it in terms of what the Title IX requirements were, but the Title IX requirements are incorporated in those OEO procedures. And the Court of Appeals did a briefer, excuse me, a more brief version of the same analysis, but it's interview all the witnesses, explore bias of, don't allow biased investigators to exercise their bias in conducting the investigation. Don't allow Ms. McAllister to label the accused as a guilty perpetrator and the accuser as a victim at the outset within hours of the complaint. Don't start with the conclusion and work backwards to find the evidence to support it. Follow the evidence and reach your conclusion.
So it strikes me listening to you, even though what you're describing is much more detailed than the words thorough, impartial, and fair, you kind of illustrate why those are vague terms. I mean, what would be, how do we know that they were biased? And you would say because they called her a victim. I don't know that she called him a perpetrator from the beginning. I don't know that she didn't. But there's so much ambiguity there, so much vagueness. Is that a problem from a contract perspective that wouldn't be a problem in the context of a suit about whether Title IX was violated, which is clearly a legitimate suit here? But the contract, what they agreed to, does seem a little fuzzy, even taking into account the details.
Well, that I think actually brings us somewhat to the good faith and fair dealing portion of the analysis. And in this case, the university had some discretion in how it followed its procedures. But the important thing in exercising that discretion is that they exercise it fairly, not arbitrarily, not in a way that avoids the intent of the parties in the contract. The intent of the parties in the contract was to allow everybody to get a fair hearing, and the intent of the way the investigation was conducted was to reach a foregone conclusion, because Ms. McAllister, as demonstrated in the record, had a great deal of bias in these cases, and she was running the program, and she was selecting the investigators, and she was instructing the investigators. If there's no other questions, I think I've probably covered everything, even though I still have 5 minutes left.
Can I ask, in terms of the allegation about the SANE report and the fact that the investigators only considered the portions of the report that were submitted by Jane Rowe, what procedure does that allegation refer to? What specific procedure?
I'm sorry, Your Honor, I don't have the procedures committed to memory, so I can't tell you. But it's obvious that if you have a 15, 20-page report and you select 3 pages of it that supports your claim, that an impartial investigator, an impartial judge, an impartial jury is going to want to know what's in those other pages. And that goes directly to whether or not the investigation is thorough, whether you're reviewing all the available documentation. I believe there is a provision in the OEO procedures that says we're going to look at all the available documentation.
Got it.
And having the complete SANE report would do that.
And
Okay.
when you said 15 to 20-page report, that we only use 3 pages, is that, are those actual numbers?
No, those are illustrative. I don't know how many pages there were. My recollection is the whole thing may have been 5 pages, and she redacted portions of all the pages just to show the portions she wanted shown.
Okay.
And if it turned out that some of those, the redacted part were really sort of largely irrelevant, let's say personal health history, things of that nature, your position isn't, at the end of the day, the person that brings the claim in the first place, in every instance, if there is a SANE report, has to provide the entire thing. Is that your position?
I think the investigator would be the person that should redact those portions. If the investigator is indeed an independent, fair investigator, just as sometimes judges review sensitive documents in camera and make edits before they're given to opposing counsel, same sort of thing probably should happen here if that's really what's going on. But we can't know because we don't have it.
Did the investigator inquire into why the redactions were made, or?
Not according to the record that we have. They
Okay.
just accepted it.
And did the investigator consider that in their final recommendation or report, the fact that they only had portions of that report and that there may have been other information that they were missing that could be
They kind
relevant?
of brushed it off, that it wasn't important. That
Okay.
there was obviously only the relevant portions had been provided to them because they believed in Jane's good faith rather than examining her motives. Thank you, Your Honors.
Thank you, Mr. Marabella. Mr. Richards, you've got a little bit over 6 minutes for rebuttal.
Thank you. I'd like to start briefly with the record. I know the court will examine the record closely. Suffice it to say, I disagree with a number of things that my colleague has said about the record. The investigators did actually consider the limitation of the SANE report, and there's no dispute here that the remainder of the record wasn't available. And so if we're looking at whether or not the university considered all available evidence,
When you said the remainder of the record, I'm sorry, what do you mean?
the SANE report.
Oh, the remainder of the same report.
So
Okay.
the university's obligation, going to the question of what are the specific procedures here that we allege were violated, well, the university considers the relevant evidence that's available to it. Jane Doe isn't a defendant here. She's not been asserted a claim against for not providing the full report. The university can only review what it has.
The university could, or an investigator, if they were concerned, could have asked Ms. Rowe, can you provide the rest of the report, or at least inquire? I understand what you're saying. They can't go get it, but she provided it. They could ask that in the course of the investigation, correct?
That's true, but again, they can only actually consider what is provided to them. And so at the end of the day, if if a party in one of those processes makes a decision that they're not going to provide private health information for good reasons or for bad.
Could they though discount the importance of the SANE report if only part of it was provided?
They could, and I think that's what happened here. I mean, I think what they were careful to say was, if we had the rest, we'd consider it. but we can't ignore what we have just because we don't have the rest. I think that would have been improper as well, and we may be here with Jane Doe on the other side of the bar if we had done that.
Well, maybe, and forgive me if I'm not remembering the record here, it may have been in the 10th Circuit opinion, there was concern that what the SANE report said was inconsistent with her testimony. Were there inconsistencies with the injury she was alleging, as I recall? Am I misremembering that?
I believe, that's not my recollection, Your Honor, I don't have
Fair
it in
enough.
front of me, but I would like to return to that point briefly because Justice Samwar's question earlier was a good one. Please recall that Judge Brimmer reviewed this record prior to it getting to the 10th Circuit, and he concluded that all of these procedures were followed. He entered summary judgment, and he said there's no issue here. And so to the extent that we have disagreement among jurists, I suppose that's understandable. Reasonable minds may differ sometimes, but this isn't a case where it's clear that these procedures weren't followed. And in fact, I think it's the opposite. And
But doesn't that prove that we got a fact question? I completely agree with you. A lot of very smart judges have looked at this and come out different ways. I completely agree. The 10th Circuit opinion was pretty strongly worded. Doesn't that all suggest we have a fact question?
I don't believe it does, Your Honor, because the 10th Circuit was focused on whether or not the facts at issue could constitute gender discrimination, not whether or not they followed the specific procedures.
I agree with that.
So, and mindful of the time, there are a couple of other things that I'd like to cover here. The first is that, let's get back to this jury question, whether or not fair can go to the jury and whether or not it actually provides a fact question at all. And the example that we use in our brief is a cell phone contract that says, we'll provide customer service promptly within 90 days. And the question is the same as the question here. Would it be reasonable to say, well, prompt has to be read in the context of the entire agreement, and we don't think that 90 days is prompt. And so therefore, we're going to ignore the specific provision, and we're going to say that promptness goes to the jury. Is 90 days prompt? Well, maybe in tort we ask about reasonableness, but not in contract. In contract, we submit specific questions to the jury, which the court has determined as a matter of law are the obligations under the contract.
But doesn't Mr. Doe here assert that certain specific terms were not followed, that his witnesses were not interviewed?
So to that point, I would urge the court to actually review the EEO procedures carefully. The procedures don't say we'll interview all your witnesses. The procedures say we'll interview witnesses as necessary, which gets to my final point for the day, which is discretion. These cases are always contested, and the investigators always have to make decisions about what to pursue and what not to. If there are 15 witnesses that are all going to say the same thing, and as in this case, the party tells the investigator, here's what these witnesses are going to say. Why would you like us to interview these witnesses, Mr. Doe? They're going to tell you that on the night that this happened, Jane Doe came into my room and I left with her. Well, okay, we agree that that's the case. So what's the problem now about not interviewing the two witnesses? The investigators have to exercise discretion in conducting this investigation. And unless this court is inviting every single one of these cases where one party disagrees with the discretion exercised by an investigator to end up in district court, that can't be the rule. The rule can't be we're going to review every discretionary decision that's made merely because this policy includes the word fair.
So the larger point still troubles me, and that is that in some instances it seems that you could have what many people would perceive as a very one-sided investigation. And after we're finished parsing through all these things, which you've done in a very, very thorough fashion, maybe not the right word to use here, but there's no avenue left for someone who's suffered significant reputational harm because of such an inadequate investigation or a one-sided investigation. So I guess my question for you is, what avenue does someone have in this instance, if any? There's Title IX, but for the reasons that have been discussed, maybe that's not sufficient. Can you help me with that larger question?
Sure, and I see my time is up, so I'll answer your question, and then I'll have a seat, if that's all right.
Please, thank you.
I believe the answer is, A, there is a remedy under Title IX. I'm not sure that we would agree that it's insufficient, but I think the better answer for this court's purposes is that the legislature has thought about these issues and acted on them. It passed legislation only a few years ago dealing with institutional obligations in these situations. That legislation is enforceable by the government of Colorado, and if the legislature wanted there to be a private right of action for a student to sue under those precise circumstances, Justice Hood, it clearly could have done so in those circumstances. We live in a society where there are at-will termination rules in employment too. Sometimes an at-will termination isn't fair, but the legislature hasn't deemed fit to create a private right of action under those circumstances, and this court hasn't either. And so sometimes that's just the way that the rule of law operates.
Chief, may I ask a question?
Sure.
So do you agree that the specific procedures in the policy we're talking about here establish promises by the school such that if they are violated, they can give rise to a claim for breach of contract?
So we have avoided taking a position on that, Justice Simler, and I'd like to continue to avoid it, but the way I'd like to answer that question is that, again, without characterization, actually looking at what the specific provisions say, interview witnesses as necessary, provide notice, provide a report. There are no facts in dispute in this case on those issues, and the district court did an excellent job walking through them. And so I would say this court doesn't have to decide issues that aren't before it. It doesn't decide the issues more broadly than it needs to, and that's a question that can be answered really narrowly on the record. Thank you.
Thank you, Mr. Richards. Thank you, Mr. Mirabella. Appreciate the arguments of both counsel. Case will stand submitted and will be in recess for 15 minutes.
All right. Court is in recess until 10:17. rise. The court is in session.
May be seated, thank you. All right, next case on the docket is 22SC499, Great Northern Properties versus Respondent Extraction Oil and Gas, Richmark Energy Partners, and Richmark Royalties. Counsel, I'm going to ask you to come up to the podium and enter your appearance so people online will know who's speaking.
Good morning, Your Honors. My name is Patrick Room, and I represent the petitioner, Great Northern Properties, LLLP.
And Mr. Room, are you going to be doing the entirety of the argument?
No, Your Honor. The amicus curiae is represented by Tom Kimmel today, and Mr. Kimmel and I will share my time during argument.
Okay, thank you.
Morning, Your Honors. My name is Joseph Pershala, Wellborn Sullivan McIntooley, registration number 40357, and I will be presenting oral argument on behalf of Respondent Extraction Oil and Gas.
And it's pronounced Pershala?
Pershala.
Did I say that right?
Very, very close. My brother would
Say it again. Now you've challenged me. Say it again.
Pershala.
Pershala.
Yes, sir.
Okay, all right, welcome. Thank you, Mr. Pershala. All right, we are set for an hour. Both sides will have 30 minutes. Mr. Room and Mr. Kimmel, you can reserve any time you have left over for rebuttal, but I'm going to ask you to keep track of your own time, and you can begin when you're ready.
May it please the court. My name is Patrick Room, and I represent the petitioner, Great Northern Properties, LLLP. As we indicated earlier, Tom Kimmel is also present in the courtroom, and Mr. Kimmel represents the amicus curiae Mineral Resources, Inc. in this matter. We intend to divide our time. Our hope is to reserve 5 minutes for rebuttal, and we understand it's our responsibility to keep track of time in this matter. As this court is aware, this action arises out of a case that was filed in Weld County District Court to quiet title to minerals underneath the right-of-way. At issue is whether the centerline presumption applies. Petitioner contends that the centerline presumption has not been historically and should not be applied to rights of mineral estates underneath rights-of-way. While both the trial court and the Court of Appeals recognized that the issue is one of first impression, neither court treated it as if it were by failing to examine whether the criteria for application of the centerline presumption apply. When the basis for application of the centerline presumption are considered, this court should conclude that the centerline presumption should not be applied to mineral rights underneath rights-of-way. The issues before the court today raise questions of stare decisis, dicta, and application of the common law. I want to start today by addressing stare decisis and discussing the line of centerline cases that address the centerline presumption in Colorado. Under the doctrine of stare decisis, courts are required to follow earlier judicial decisions when the same points arise again in litigation. Extraction, in its answer brief, argues, quote, courts for over a century in Colorado have applied the centerline presumption and the highest estate rule to all interests without exception. However, the trial court and the Court of Appeals both correctly found that the application of the centerline presumption to mineral estates underneath rights-of-way is a matter of first impression in Colorado.
Sorry, good morning. It strikes me that, yes, it's a matter of first impression, and part of why it's a matter of first impression is because at the time that these lands were conveyed, mineral rights were of almost no value because you couldn't get to them. And so now what we're confronting is a world where technology has made these mineral rights very valuable. And all of a sudden we're being asked, should we treat these the same or differently because of new technology? But should the fact that something that was not accessible at the time of the sale of the land, but is today accessible, should that define how we think about the legal rights?
That's a good question. I don't think so, because I don't think that's factually accurate. These minerals have always been valuable, and if you look at the City of Leadville versus Bond Mining Company, which was decided in 1906, the issue in that case was who has control of the minerals underneath the right-of-way. And in 1906, Bond Mining Company was mining underneath the right-of-way. When we talk about the centerline presumption in this case, we've done, I think, a disservice because we typically frame it as an oil and gas question. But the centerline presumption at issue today applies to all minerals, not just oil and gas. And there are other ways to extract minerals. And then, just as hard as the Court of Appeals pointed out, you can still produce minerals if you own land on the other side of the street. You could drill a well, and that would pool with minerals underneath the right-of-way. So even before horizontal drilling, they did not have value. Obviously, oil and gas rights are more valuable today, and more oil and gas can be produced. But historically, at least since the Bond case, minerals have been produced and are valuable underneath rights-of-way, and that's an important point in this case.
Well, let me explain. Good morning to you, Mr. Groom. Let me just share my concern here. I hear what you say, that we had the centerline presumption for a very long time. And yes, there was no distinction between mineral rights and surface rights. They don't discuss it. And yes, the courts here have said first impression. But there was, taking the other side of that, none of these courts accepted mineral rights. They stated very broad rules about the centerline presumption. And there's an argument to be made here that people relied on that. You know, if you want to preserve mineral rights, say so. So here we are 50 years after the developer made the conveyances really at issue, and now they're coming forward. And I worry about throwing property rights into great disarray now. Were we to change the rule, were we to go where you go, and I'm playing devil's advocate with you, I worry about just the plethora of litigation we're going to see from people saying, hey, I guess I own those mineral rights all these years. So help me understand why changing the rules of the game now doesn't create a great problem.
And if I can tack on to that, the creation of a market for those rights, which is what happened here, I believe.
Friendly amendment accepted.
Well, to answer your question, Justice Gabriel, I don't think we're changing anything. I don't think the centerline presumption has ever been applied towards minerals. I appreciate extraction in its brief argues that it has, but there's no evidence before the court that that's actually been the practice. And Mineral Resources, Inc., in its affidavit submitted in its amicus curiae brief, indicated that wasn't its practice. And then, in fact, they recognize the developer of the right-of-way as the owner of those mineral rights. And if that's the case, I don't think we're upsetting the apple cart because it's never been recognized and necessarily accepted in Colorado that that's the case.
But I wonder about that. I mean, no one's challenged it either. I mean, the rules are quite broad. I mean, you convey the property goes to the center line, and there was no distinction in mineral rights, so the presumption would be the mineral rights were included until somebody challenged it, which is now happening. Right. I mean, so I mean, I understand what you're arguing, and I understand. I've known Mr. Kimmel for a long time, and I have great respect for his knowledge in this area of law. But that's one party's position. I get that, but this has been 100 years of nobody's contested that the mineral rights were excluded either. So help me with that.
And at times, just a friendly amendment. At times, we've actually been more express about it. I mean, in O'Brien. A 1990 case, so 33 years ago, we said it is well established that a conveyance of land by general description without any reservation of a mineral interest passes title to both the land and the underlying mineral deposit. So very broad statement that specifically refers to mineral interest.
Justice Amor, I want to address that question because that's an important point. But to continue to answer Justice Gabriel's point, it hasn't been contested because no one cared about the minerals adjacent to the right-of-way. The centerline presumption was adopted as a common law principle to address the road and the right-of-way. What happens to the reversionary interest when that right-of-way vacates? That's why we have a centerline presumption, and that's why it arose under the common law. In Colorado, people have not been concerned about the minerals until producers like Extraction have made determinations that the developer doesn't own those minerals. And once that determination was made, that ownership became an issue. And the centerline presumption was applied by Extraction to the minerals. And as a result, the developer had to litigate to protect its rights. And that's why it became an issue. Whether or not most developers rely on the centerline presumption, whether or not most producers rely on the centerline presumption, is not a question we can answer today. Surely there's probably a split in how people have approached that question. But I think the reason it hasn't been litigated is simply because abutting property owners have only been interested in ownership of the right-of-way. That's what matters to them. What can I do with the surface? Not what can I do with an oil and gas rig, and can I produce minerals? I mean, typically we're talking about a very small area of land with respect to the adjacent property owner, 50 by 100 feet.
Well, with horizontal drilling, though, is that still a correct statement, given sort of some of the things we've seen in the news? And is that correct?
Well, what's at issue is correct. What's at issue for the adjacent property owner is only ownership of the minerals underneath the right-of-way to the center line of the road. So if their lot abuts the road and the road is 60 feet, we're talking about 30 feet times the width of their lot. That's what's at issue for the individual lot owner. What's at issue with horizontal drilling is a much broader area that's produced, but that involves potentially hundreds of royalty owners. The individual lot owner only has a relatively small interest if they have a small parcel. The developer, on the other hand, has a significant interest. The right-of-way could be 60 miles long. 60 miles times 60 feet is significant acreage. And so for the developer, it's a very valuable interest. And that's why we're litigating today, because it is an interest that has value. And because it has value, the centerline presumption should not apply.
And can you help us understand why the division got its reasoning in terms of the highest estate presumption wrong?
And that's Justice Moore's question as well, I think.
Yeah.
We don't dispute that principle, but the point is, under O'Brien and under cases that interpret deed construction, the highest estate rule applies to what's described in the deed. If I convey to you parcel A, O'Brien says I don't convey to you parcel B that's adjacent to A. So the centerline presumption is actually in conflict with the highest estate rule. The only reason it becomes an issue with the centerline presumption is because if the centerline presumption applies, then that land is included within the land described in the deed. But you first have to determine that the centerline presumption applies. If it doesn't, O'Brien, Brown versus Kirk, dictate that nothing else besides what's described in the deed should be conveyed. And so no land underneath the right-of-way would be conveyed with the adjacent parcel. It's only after you apply the centerline presumption that that becomes an issue. And
I guess I have to ask you, it's an interesting point you're raising. Why isn't it the other way around? I mean, the general rule is the deed conveys what it says it conveys. And then common law created this exception, if you want to call it that, called the centerline presumption. So why don't you, and here I expect Mr. Prashala to get up and argue, and that's been, everybody understood that 50 years ago when the developer made these conveyances, they understood the centerline presumption was an overlay here. So everybody went on that presumption. So I guess my question is, why don't you start with, the deed conveys what it conveys, with an exception here called the centerline presumption?
I think you do start there, Justice Gabriel, but the question is, what is the centerline presumption? When you say it's conveyed with the centerline presumption as a rule of conveyance, what is being conveyed? Is it just the fee determinable interest that was recognized in bond in 1906. The Bonn court, this court in Bonn, determined that the surface fee determinable interest that a municipality has is separate and distinct from the underlying mineral interest.
Right, and that was a dedication situation, and it said, you know, when you dedicate the road, you're going to convey the surface and enough below the surface that lets them build the road, and that makes some sense. And there's a reversion interest there when the road gets vacated and you get it back. I mean, I guess this is going to get us into Moorcroft and that issue of whether you have a vertical severance. But, I mean, that's what that was dealing with, right?
It was, and that's the reality. That's what a road is. I mean, the right-of-way is a right to use the surface to a certain depth, and that's what is at issue with the centerline presumption. What happens when that vacates? What extraction is proposing creates an odd scenario where you've got two property interests, the mineral estate and the surface estate, which is burdened by this right-of-way, which in the case of statutory dedications is a separate fee interest with the possibility of reverter. Extraction is saying one is conveyed immediately when you convey adjacent property, i.e. the mineral estate, but the other one's not conveyed until some possible remote time in the future if the road's vacated. But it's the latter interest. It's that possibility of reverter, which is what the courts have been looking at historically with the centerline presumption. As all of you know, in Olin, Overland, Scarrett, Asmussen, what was at issue in all of those cases was who owns the right-of-way now that it's been vacated? That was the issue. The issue wasn't what did someone receive when the property adjacent to the right-of-way was granted. The question has always been, what happens to this property interest that was held by someone else, i.e. the city, the county, the state, that's now been vacated and has now been, we now have to determine who's entitled to ownership of that interest.
Are those two different things here, though? And forgive me if I'm just showing a whole lot of ignorance in this area of law. I can understand on the dedication scenario, if you have the interest is vacated and it comes back. What you get back, arguably, you know, would be just the surface and whatever below that you dedicated. You get that back. I mean, the vertical severance issue essentially says now the minerals and the surface are severed horizontally and vertically forever, so you can sell the minerals separately. That's one scenario. But the other is when you just have a conveyance in fee of the property. You know, I'm the abutting owner, I own the property under the road, and I convey it, not a dedication scenario. I mean, aren't those two different things?
I don't think so, Justice Gabriel. In the trial court...
And let me just clarify, because there's no reverter. I mean, the way you're construing the centerline presumption is only applies if there's a potential reverter interest. It sounds to me like that we only consider it if there's going to be what happens when a road gets vacated. I'm not sure the centerline presumption is that narrow.
I believe it is. I believe that's why the centerline presumption arose at common law. We had to determine who owns that right-of-way when it's vacated. It's never an issue before the road vacates.
Well, where's that? And I'm obviously just pushing on you here, and you're educating me, and I apologize, and thank you. Asmussen doesn't seem to be that limited. I mean, it seemed that the concern in Asmussen, as I understand it, seemed to be this problem of having these, you know, very narrow strips of road that are valueless to anybody. And that doesn't have to do with whether it gets vacated. It has to do when you sell it.
Well, I want to be extremely deferential to the court regarding Asmussen since the author of the decision is sitting in front of us. But Asmussen was addressing a very narrow question, and that was the question certified by the Federal Court of Claims, and that was who's entitled to that vacated right-of-way? That term was used, right-of-way, in the question certified to this court. And there's no evidence in Asmussen that minerals were at issue. There is no evidence that the dedicator, the grantor of the easement in that case, owned minerals underneath the land burdened by the right-of-way at the time the right-of-way was dedicated. Perhaps the same reasoning applies, but there's no evidence that the minerals were at issue in that case. And so I don't think the holding in Asmussen applies to minerals. Whether or not this court was considering minerals when it authored and issued that opinion, I obviously can't say, but I don't think minerals were at issue. What was at issue was did the adjacent property owners have a claim to that land? And did they have a claim based on the correct title? And could they assert a takings claim? But what was at issue was the vacated railroad.
But where does it, and I'll stop. I know I'm taking up too much of your time, but the language in Asmussen is broader than that. If the grantor owns the fee underlying the right-of-way, it is presumed the grantor intends to convey it, because a grantor generally does not intend to retain ownership in a narrow strip of land that is of little value to all but the adjacent landowner. I mean, a standard concept of the centerline presumption, it doesn't talk about only if it's vacated, only if there's a reverter interest.
No, I agree. But if the court had been considering the bases for applying the centerline presumption to minerals in that case, i.e., number one, that the property interest has no value to the owner, and the only value is to the abutting property owner, and also considered the second issue, which was, is ownership of small strips of land going to result in litigation? I think the court would have concluded that those don't apply to the mineral estate. The mineral estate is an incredibly valuable interest, regardless of whether the owner of the land underneath the right-of-way conveys an abutting lot. If that analysis is thoroughly examined or exercised, I think the conclusion is that the centerline presumption basis has no application to the mineral estate. That would be true, as Justice Hart had suggested earlier, if the minerals couldn't be produced. But they have always been able to be produced in Colorado. They can be produced today. With pooling rights in Colorado, oil and gas could have been produced from an adjacent property, and that land underneath the right-of-way would have been pooled. And that was the precise conundrum that the Court of Appeals ran into. The Court of Appeals, in examining this question, said to itself, these interests have value at least at some point after an abutting property is conveyed. How can you say that the oil and gas interest or the mineral interest has no value when you own the land on the other side of the street? You could put a well in the ground and you could produce those minerals. So clearly, when you examine the bases that the court recognized in Asmussen for application of the centerline presumption, it does not support applying it to the mineral estate. And the court has not gone through that analysis prior to today, I don't think. And primarily because the issue has not been before the court.
So in that regard, there's sort of not a right answer to this question. There's just an answer. What you need from us today is for us to say who has these mineral rights. And I think I read in the briefing that here the question is just who ends up getting the royalties on production of oil and gas. We can pick whichever rule we want to.
I think there is a right answer.
You think the answer is the one that you want, but I appreciate that. But take my question seriously for a minute, and I understand that you would want the right answer to be your answer, but at this point, there's not a sort of an inherent answer to who owns this property. It could have been conveyed with the land, or it could not have.
No, I agree with you, Justice Hart. There are only two answers to the question.
Right.
I think one of them is right, and I think historically there's been no conveyance of that mineral estate to the adjacent property owners. There's no deed that conveys it. And if you don't apply the centerline presumption, there's nothing that supports a conveyance.
So let me,
Isn't there?
oh,
Sorry.
sorry, go ahead.
I just to close it out, there's something I guess I find a little counterintuitive about the idea that we might apply this centerline presumption to the surface rights, but not to the mineral rights. I mean, we haven't divided those out typically.
Well, Colorado has always recognized that the mineral estate can be separated from.
Could be separated. But,
Well, yes. Okay. And I think in the Bond case, this court recognized that there is a severance. When you dedicate that right-of-way, you've severed the surface estate for the road from the mineral estate. That creates a severance, and you can convey one of those property interests through the centerline presumption, i.e. the fee simple determinable that's created in the road without conveying the mineral estate.
But do you have to do that expressly?
I don't think you do, because the centerline presumption is saying, in my opinion, that the property interest that's going to revert at some point, if it does, that is being conveyed to the adjacent property owner. That's what the centerline presumption has historically accomplished, and I think that's what it's intended to accomplish. If I'm correct, then there's no need to reserve the minerals underneath the right-of-way when you're conveying adjacent land, because it's a completely separate estate.
So I think you answered my question, but I was trying to make sure that I understand your position correctly, and I may be showing my ignorance here, but if you have a situation where that doesn't involve mineral rights, take mineral rights out of it, and land that's abutting a right-of-way is conveyed, you would agree, I think, that the centerline presumption applies in that situation, correct?
Yes.
All right. Same hypothetical, but now there are minerals underlying the land. In that situation, the centerline presumption would apply only to the surface land, but not to the mineral rights. That's your position, correct?
Yes.
Okay.
That's exactly our position.
And your rationale for that is that the whole point of the conveyance of the right-of-way is a surface-based conveyance. It's all about activity at the surface.
That's correct, Justice Marquez. I mean, the only purpose for the right-of-way is to create a road, or a railroad, or a trail, to allow someone to use the surface to access their property. That's the appurtenance that the court talks about in Olin, when in Olin the court said, the grantor conveyed all the appurtenances to the adjacent lot. The appurtenance was the road as an access to that property. It was not the mineral estate. Land can never be appurtenant to other land. And the mineral estate is a separate interest in land. And the Olin court was not considering mineral estate at all when it talks about appurtenances to land. It talked about exactly what Justice Marquez is addressing, which is a right to access a property, to utilize the road for transit. And that's the only property interest that the centerline presumption is intended to address. Historically, the centerline presumption dates back to the 1500s. Roads were invaluable at that time. Below the road was just Dante's Inferno. There was nothing to be worried about. They weren't worried about oil and gas. They weren't worried about other minerals. They were just worried about the road and what they could do with that road. I'm happy to answer more questions right now, but I have 4 minutes left, and I do want to reserve some time.
And we want to hear from Mr. Kimmel, I think.
Well, go ahead, Mr. Gill. Thank you.
Please the court, Thomas Kimmel on behalf of the amicus curiae Mineral Resources. I plan to use the small bit of time I have today to discuss industry custom and practice as to subdivision streets in the city of Greeley. I submit that the experience in Greeley is highly relevant to this case because Greeley has more oil and gas wells and associated spacing units that include subdivision streets and subdivisions than any other city in Colorado. And Mineral Resources historically has had a unique status as the primary operator and lease taker in the city of Greeley. So the first important bit of information that comes out of Mineral Resources in Greeley's practice is that oil and gas development and the recognition of the value of minerals has been taking place in Greeley since the early 1950s. So in the present case, we have deed conveyances that occurred in 1974. And I think this information strongly suggests that the presumed intent of a dedicator in 1974 was to view the minerals as valuable and not as worthless, and not to intentionally relinquish that mineral interest. A second important bit of information that comes out of Greeley's experience is what are the customs and practices that were followed. And as Mr. Groom indicated, and you might have seen from our affidavit, Mineral Resources has consistently followed the principle that absent a street vacation, which is interpreted by statute, which occurs by statute and would apply both to surface and minerals, that the dedicator, the last known owner of the minerals, is treated as the owner of the minerals. And this is consistent with very important rule of deed construction, which is that a deed only conveys the property that is described in the deed, and the center line rule is not an absolute exception to that. It's simply a presumption that your ordinary rules of deed conveyance don't get followed in certain circumstances. But to expect a developer who conveys a lot in 1974 to know that they have to reserve the minerals in a property that they didn't even convey defies common sense. Deed construction rules are important, and I submit that the court should not deviate from those deed construction rules unless there is good reason to do so. And the good reason would be that the presumed intent of the person was to view the property as being worthless, and that's simply
Mr.
not the
Kimmel?
case in this case.
I'm sorry, Mr. Kimmel.
Sure,
Good
please.
morning. Would it matter if it was 1874?
Well, I think it would be a different situation. See, that's the interesting thing about the centerline presumption is it's not a absolute exception. You're trying to serve two policies. One, prevent strips and gores, and two, the presumed intent of the developer. I think the intent would be different in 1874. But I think by 1974, the presumed intent was that it was viewed as the minerals were viewed as a valuable asset. One final thing, 12 seconds, I see we have left. Mineral Resources has the advantage of taking a lease from the dedicator. I'm sorry, my time is up. But anyway, they've taken leases from the dedicator. It covers 60 acres. And it's much more efficient to do it that way than to take a lease from hundreds of adjacent lot owners.
All right, thank you, Mr. Kimmel.
Chief, can I ask a question of
Sure.
Mr. Kimmel?
Yeah.
So, Mr. Kimmel, in a situation in which we have property that abuts a right-of-way, and let's say that property is being conveyed and the property has mineral interests underlying it, and there is just a general conveyance, you would agree, I think, that that general conveyance would include the mineral interest. It would include everything, right, including the mineral interest underlying that property.
Yes,
But-
under that greater estate rule, as
Right.
Judge Hart mentioned.
Okay, but
I agree, but
And then you would say that the presumption, the center line presumption would apply in terms of the surface only. But if there are minerals underlying the right-of-way, those minerals would not be conveyed.
yes, because that greater estate rule has only been applied to the property that's described in a deed
Right.
and has never been extended to rights that were not addressed in the deed.
And that the deed did not envision.
So if you give a deed to a lot owner, even if you don't say I'm conveying the minerals, they get the whole ball of wax as to that lot,
Unless you reserve it in the deed.
unless you reserve it.
Correct.
But to apply it to property that's not even mentioned in the deed is something that no court has done, in my opinion, based on my research.
Got it. Thank
Thank
you.
you.
Thank you, Mr. Kimmel. Mr. Prishala, when you're ready.
May it please the court, my name is Joseph Pershala on behalf of Extraction Oil and Gas. The outcome that GNP seeks here today is to upset more than a century of well-established law in the state of Colorado. It would invite immediate speculative litigation, just as GNP has sought in this case, and it would disgorge property rights as well as monies from unsuspecting landowners that have relied on this presumption for decades and enjoyed the benefit as it's been applied to their mineral interests. While this case does seem to present a novel question, this court's well-established jurisprudence already answers it the centerline presumption applies to the highest estate, which is the fee estate, unless there's a contrary intent expressed in the deed. The lower courts both found the same, and we agree with the lower courts. We'd ask that this court affirm the Court of Appeals. And the starting point for any deed interpretation is the highest estate rule. And that is, everything is conveyed that the grantor owns unless there's an express intent on the face of the deed otherwise. That is what the Olin Court holds. And that most valuable estate includes the mineral estate. And without an express reservation, the surface and the minerals stay unified. Both, if we look at O'Brien and we look at Radke, absent a reservation, that estate stays unified. And the court in Asmussen started with these same statements of law. It's undisputed that in 1974 and 1975, that the original developer conveyed the abutting lots without any mineral reservation. That is, the entire fee estate went to the abutting lot owners. I don't think that's disputed here, even by GNP. In light of the highest estate rule and the law regarding severance of mineral estates by express reservation, the centerline presumption, which has been described as an overlay, as a rule of conveyance, must apply to that fee estate, unless there's a contrary intent. This is consistent with how the centerline presumption has been applied for over 100 years. GNP's position is that despite these deeds having conveyed a fee simple interest in the abutting lots, is that the centerline presumption, and Justice Seymour and Justice Hart, you both touched on this, that they're asking that the centerline presumption not be applied uniformly as to the fee estate, as to that unified estate. They're now asking that you only apply the centerline presumption to the surface estate and treat the mineral estate as a separate and distinct estate, but there is no severance. To adopt this position of the centerline presumption as applying differently to the estates would mean that the centerline presumption is affecting a severance of the surface and the minerals.
Well,
There's simply no basis for that in the law.
sorry to interrupt. Can I ask you about that with regards to the second question that we granted cert on? I've been struggling to understand what the world would look like if the centerline presumption applies so long as a seller of land, as I understand the question, so long as the seller of land does not own any adjacent land to the road at issue, the centerline presumption applies. But if the seller of land owns any land, then the centerline presumption does not apply? Am I correctly understanding the assumption behind the question?
I think when we're talking about the second question, we're talking about this timing element that the Court of Appeals put in place. I too am struggling with that question of where that came from, number one, and how that would even effectively apply.
Because, so I'm imagining in my mind, here's the north end of a road, here's the south end of a road. I'm imagining a property owner who owns property down here, owns property up here that she sells. Under the Court of Appeals opinion, the centerline presumption wouldn't apply to the sale of this property because of the ownership of this property? Is that how you understand the?
That is how I understand it, is that if so long as the original grantor retains some interest, and whatever that interest might be, it could be a fee, it could be a mineral, it could be a surface, it could be an easement interest. I'm not sure what that interest needs to be, but so long as there's a retained interest, then that lot owner up here, the centerline presumption would not take effect until that interest is conveyed away. That's what the Court of Appeals came up with.
Okay.
I'm struggling with that, the basis for that myself.
So you think that doesn't make sense?
No, it does not make sense. And it's an issue that should never have it was never an issue that was noticed for appeal to the Court of Appeals. And it's an issue that was never in dispute because we know that in this case, all of the lots have been conveyed by the dedicator in 1974 and 1975. I think that approach, this timing element, creates a host of issues, and I think in the briefing, both parties agree that there's a number of issues with that. But more importantly, I think that Asmussen, it's in direct conflict with Asmussen. Because Asmussen is saying that the centerline presumption is the rule of conveyance, which presumes that the grant, I'll leave it at that. I think it is inconsistent with Asmussen.
And it could also cause other problems, right? If you had somebody who had a huge ranch, right, that runs along a road, and the family sells off sort of pieces of the ranch over time, ultimately, let's say, does a conservation easement. I mean, how does that work?
I think it's unworkable.
Okay.
And my point about how it's inconsistent with Asmussen is that at the end of Asmussen, it says that in order to have the centerline presumption applied, that the owner or the abutting lot owner needs to prove up their title. Well, in Colorado, under our race notice statute, you're only obligated to look at your own title. This timing element would require you to look at title along the entirety of the right-of-way. And when we're talking about lot owners and individual landowners, they don't have the resources or the sophistication to do that. And that's a burden that I think is far beyond what the Asmussen court intended to apply.
So just to confirm, I think your position here is you disagree with this element, but your view is it doesn't matter in this case anyway.
That's right. And that's why in our briefing, we suggest that the second element, or the second issue, this timing element, is really dicta. And we would ask the court just to acknowledge that or reverse on that element.
So separate and apart from that second issue, tell us why Mr. Groom and Mr. Kimmel are wrong about the centerline presumption applying only to the surface of the right-of-way and not to the mineral rights underlying it. I think Mr. Kimmel said that it doesn't make sense to do something different, and I think he mentioned no case has ever done that. So why are they wrong?
Well, I would posit that they have not explained why the centerline presumption should treat the mineral interest differently from the surface interest. I think that's the starting point, is that when we're starting with the highest estate rule, that everything is being conveyed by the grantor to the abutting lot owner, and then we overlay the centerline presumption, there is nothing in that presumption that would create a severance from the mineral estate. And then there's been this discussion of bone in the city of Leadville as though that dedication somehow severed the surface rights from the mineral rights, as though those are, the surface is included with the road, but truthfully, the road is just an overlay on the surface estate, which still is unified with the mineral estate across both, underneath the road.
So the dedication, and this is a question, not a statement, in your view, the dedication is not actually conveying, it's conveying an easement at some level, but the dedicator still owns the mineral and surface rights subject to this easement in the surface. But that doesn't effectuate a severance. Is that what you're saying?
Absolutely. Even after road dedication, and even after when the road is in place, the surface owner still has the right to grant easements such as tunneling for cabling,
Water.
pipeline, water, underneath, thank you, underneath the road. That surface estate is still unified. And I don't believe that GNP has given any legal basis or policy reason for why you would why you would essentially sever the mineral estate when you apply the centerline presumption.
Can I ask you, while you're pausing, to respond to Mr. Groom's argument that the centerline presumptions always dealt with vacated rights-of-way and reverter interest?
Has the centerline presumption only applied to vacated?
If I understood him, and forgive me if I misstate Mr. Groom's argument, he said if you look at all the cases, they dealt with vacated rights-of-way.
Well, I'm not sure that that matters, because we're talking about a rule of conveyance that takes effect at the time that the lot is conveyed. And at that moment in time, the road would be in place. We're only talking about how we should be treating this later on, but the rule took place at the time of conveyance. And this gets back to the second issue of having this sort of springing issue based on a timing element is that to have certainty in the law, certainty in property rights, we need to know when these interests are fixed, and they're fixed at the time of conveyance. And I think I'll leave it there.
Sort of curious why we're fighting about this. I mean, at bottom, again, and I don't remember whose brief it was that said it, but this is just a question of who ends up getting paid royalties, right? It's not a question of more royalties to one party or another.
For purposes of extraction, my client has leases both covering from the original dedicator as well as from the lot owners. So for purposes of my client, its rights are protected, but it has to pay somebody on these interests.
Right.
And it's been paying the lot owners according to Colorado law, well-established Colorado law, on this strip of minerals underneath the road. Now, so for purposes of this case perhaps alone, it's really a distribution question, but the implications of this case are far-reaching.
Okay.
Because
The property owners are going to lose the interest here.
they're going to lose their interest, and then,
But they're not here
But the-
anywhere right now, right?
correct. But they've been paid, and then who is going to repay that money?
Got it. Okay.
Is G&P going to go to extraction, or is G&P going to go to the lot owners and say, you need to pay us what they're going to claim unjust enrichment by all of those lot owners, potentially even conversion, civil theft. There's a number of claims that could be asserted against those lot owners if the court was to reverse the Court of Appeals. G&P's theory really boils down to that a dedication is severing, creating some sort of severance, and arguing this through Moorcroft. There's nothing in Colorado law that suggests that a severance occurs upon a road dedication. And there's also been a lot of discussion about value, that mineral interests have incredible value, that these developers knew in 1974 that there's value to these mineral estates. If that's true, the developers would have reserved the minerals under the lots. They did not. And when we override the centerline presumption, we have to understand that the intent of the grantor, based on the face of the deeds, was not to reserve any mineral interest in these lots or the road. Technological changes, and the court has already addressed this, technological changes do not change this outcome. We need to consider these deeds at the time that they were executed. We can't evaluate a grantor's intent based on technological advancements that happened 40 years later. I think what's also equally likely here is that the deed's silence on the reservation of the minerals is evidence that the abutting lot owners ascribed their own value to the minerals. It's just as likely that they bargained and paid consideration for the minerals under their lots and under the road. Because at that time, all parties knew that the centerline presumption applied to conveyances that do not have a mineral reservation.
And they are presumed to have known that, right? I mean, we have to presume that they understood that.
Correct. We agree. I think G&P tries to argue that, unlike narrow strips of surface, slivers of the mineral estate may have value based on the nature of oil and gas development. I think we need to set aside that industry attributes are not relevant to interpreting an absolute deed that does not have a mineral reservation. And that existence of some value does not preclude the application of the centerline presumption. Indeed, in Asmussen, the court does not say no value, the court says may have little value. I think we already touched on the fact that surface rights, even under a right-of-way, still have some value, but yet we're still applying the centerline presumption equally to those interests.
why should the centerline presumption apply to the mineral estate when historically it was created just to address the rights of way on the surface? You know, you talk about what people would presume over time, but the body of law really address what's happening at the surface. I think this is Mr. Groom's point, right? So can you respond to that?
Yeah, I understand that it may have originated in dealing with issues related to the surface, but the jurisprudence that leads to this centerline presumption doesn't distinguish with respect to surface or mineral estate or any estate. It's saying that when we have fee conveyance to the abutting lot owners, that the centerline presumption is going to apply to the entirety of that fee conveyance. And that's the same situation we have here. So I would just go back that this, while the presumption may have been created to address potential issues with the surface, it's not so limited. It's intended to apply to the entirety of the estate.
Intended by whom? And what source of law specifically says that? And forgive me if I'm just being ignorant, but...
Well, I think if we look at the history of the centerline presumption, when we look at Olin, and this is the highest estate rule that on which the centerline presumption is based, is that the grantor is conveying the most valuable estate to which the grantor cede. That's everything. And then we're overlying the centerline presumption on that. In Overland, the court held that a deed conveying a lot abutting a road is presumed to convey the highest estate. Again, that is everything that is owned by the grantor unless a smaller estate is described. So the court has never been distinguishing how to apply the centerline presumption, be it surface, as to an easement, or to the mineral estate. It applies to the entirety of the estate. And I think when we look at it from that context, and if we were to adopt GNP's position, it goes back to the severing of a mineral estate. And we can't do that without an express reservation and a conveyance instrument. The court would be creating a new form of property right by adopting GNP's position.
As long as I'm talking more than I should, can you sort of give us the parade of horribles if they win?
Well, I think the first thing would be a suit against extraction and/or the lot owners, presumably both, for disgorgement of profits. I think following that, we're going to see other GNP is not the original developer.
Right.
GNP acquired these assets in the beginning of 2019 and then literally 2 months later filed this lawsuit. That is what we're going to see going forward if the court was to reverse the Court of Appeals. We will see more litigation. It will also upset title, not just in the city of Greeley, but across the state of Colorado. So you're going to have title lawyers having to go back and redo every title opinion wherever there's a street or a road that's been dedicated and there's lots of abutting on the other side. That would also require an evaluation of title, not just as to the specific property, but anywhere along a road. And when we look at this in context of a railroad, that could be to the Wyoming border. I don't think there's any, I think that is an outcome that the court could not intend.
Thank you.
You observed that the crux of the GMP's theory is that the dedication of the road creates the severance that we're talking about, and you say not true. Can you elaborate on that? Why doesn't the dedication of the road sever the surface estate from any mineral estate?
Well, we know that a road dedication is only so much of the surface that is necessary for the road and to support it. Nothing more than that. Bone mining does not say that upon the dedication that thereby severs the surface from the mineral estate. It's just simply that the city only acquired an interest in the surface upon dedication, limited to that amount of surface that is necessary for the road and nothing more. That can't be a mineral severance. Severance has to be done by express language in a conveyance instrument. And there's nothing in Bone that suggests that it's a judicially created severance instrument by a dedication.
As a matter of practice, other than, I guess, this case, have conveyances been occurring where mineral estates have conveyed with the surface rights? Would we be unsettling other circumstances other than this one, according to you? Or that was not a very good question, but do you understand what I'm?
I think so. If I understand the question correctly, would the outcome of this case affect conveyance instruments that do not abut, for property that do not abut a road? Is
Well,
that
or
the question?
just other than this set of conveyances? I mean, but you mentioned that in the Parade of Horribles answer.
Yes.
That we'd have to go through and figure out, or someone would have to go through and figure out the rights of the newest mineral estate owners. Is that true in other locations?
Absolutely.
Okay.
I'm involved in another quiet title case right now that this issue has just arisen. That there was a conveyance of property, no mineral reservation to the conveyance by the original owner to the developer with no mineral reservation. The lots are then conveyed out with no reservation. Who owns the minerals under the road? Is it the developer or is it the lot owners? It's the same question that's here, and it's going to come up again, potentially come up again in that case.
And I made a cryptic comment, I think, along those lines, that when I talked about the market being created, perhaps. I don't know enough about this.
I think that's what we have here is a market that's been created. It's not the original developer. There's been discussion about it. The developer had thought there was value in these minerals, but the original developer did not reserve them. GNP thinks there's value in these minerals and therefore acquired them for what sum of money we don't know.
So I asked you a question, excuse me, that I used loose language on it. I want to clarify and make sure I'm understanding right. I talked about it in a dedication. It was an easement. It's not technically an easement. I mean, a fee interest gets conveyed to the city. Say it's a city that it's dedicating to, and I guess subject to the reverter.
It's a limited fee, I think is how it's been described.
All right.
I agree that it's not technically an easement, but I would say it's similar in nature to an easement. Since
All right,
it's not
and-
conveying the entirety of the estate, it's only conveying a piece of one stick in the bundle.
Right, but by analogy, the owner, there's no severance here because the owner, I guess, retains a right of reverter in the surface and the mineral interest?
Retains a right of reverter in the dedicated road.
Right.
But it has still, the grantor, the dedicator, should I say, still has a unified interest as it concerns the surface and the mineral estate.
Right, they may retain some of the surface rights, the surface part that's not necessary for the road. So you dedicate whatever's needed for the road, and they retain the remainder of the surface and mineral rights.
Yes.
Okay. And that's, I guess that would be why that's not a severance.
Yes.
Because in a true severance, you would sever the surface from the mineral.
Yes. I think I've covered everything that I intended to cover, unless your honors have any further questions.
Thank you so much.
Not seen any. Thank you, Mr.
Thank you very much.
Thank you, Mr. Groom and Mr. Kimmel. We appreciate the arguments of all counsel. Case will stand submitted, and we will be in recess until 1 o'clock.
Court is in recess until 1 p.m.